Now, the design bid build or design award build has been the traditional way to get projects done in this country. It really developed post-Civil War because at that time, uh, project owners usually went to someone to build something, and that someone often designed the thing or had someone design the project and then constructed it. It was really post-Civil War where architects started looking at themselves as a separate profession, and civil engineers broke out from the military engineering group to become a separate profession. In fact, their organizations, the American Society of Civil Engineers, started in the mid-1800s, and the AIA started shortly thereafter. And part of that was to really elevate those professions and separate them from kind of a package building concept. Now, that's the way that the country developed. And over the years, we've had owners who signed contracts with architects or engineering firms, design firms, and then had the project designed, and then would put the project out to bid and have a separate contract with the contractor. Often a little bit different from this image in that it was seen as a kind of a three-legged stool. But in any case, the design firm had no contract with the construction entity, right? And that developed some problems because over the years, what would happen is the design firm would provide documents, deliverables, plans, and specifications to the owner. And the architect as a professional or the engineering firm as a design professional would only have to meet a standard of care based on negligence. You know, did this meet the standard of care? And if those plans and specifications met the standard of care, the engineer, the architect, had done the job the firm was being asked to do. The owner, however, would then take those plans and specifications and put them out to bid usually, sometimes negotiated with the contractor, but often just put them out to bid. And when the contractor bid on those documents, the contractor had to rely on the information provided. And in fact, over the years, what developed in the law was that the owner would provide a warranty to the contractor that those documents were adequate for construction of the project. Now, the first case that really went into that was called a Sperrin case, and it was a situation where the contractor built something relying on the plans provided by the owner, and it turned out that the project did not work as designed. The owner sued the contractor to modify the project, and the contractor countersued and said, look, I did it exactly as it was planned, and therefore I should not be liable. And the court in the Sperrin case, which was against the U.S. government, agreed and said, no, you had the right to rely on those documents when you provided the price and when you said you could build it. And therefore, if those documents were inadequate to come up with a project that met the owner's requirements, it is not your fault, right? So the owner had to take that responsibility. And we'll talk a little bit about the Sperrin doctrine later on when we talk about design build, because it really flips the entire situation.